Thank you. We're ready to proceed.
Good morning, Your Honors. Ms. Conklin. Cynthia Hall of Silverian Hall, PA, representing the father who's the appellant in this action. I'm confident that the court's familiar with the factual background of the case, but I just want to mention a couple of facts.
Did you want to reserve any time?
Yes, Your Honor. Thank you. 5 minutes. I even wrote it down, but thank you. The parties were divorced in 2012, and the final judgment of dissolution of marriage actually incorporated a marital settlement agreement, which provided for the parenting rights and obligations of the parties. And I think that's important for the court to know. This was a marriage that was dissolved. It's not a paternity case. And Ms. Conklin decided at that time not to have her maiden name restored. As we're all familiar with the rules, it's an opportunity at the time of the final judgment. It's one of the factors in the special interrogatories where a wife is asked whether or not she wants to restore her name. 2 years later, when the minor child is now 4.5 years of age, the mother filed a petition to change her own name and the minor child's name. After being served with the petition, the father objected to the name change for the minor child. Unless the court has any questions, I'll skip over the hearing that occurred before Judge Creer that was there was a rehearing on, and we went to trial in September. In that particular hearing, the mother went forward and presented her case. Our brief outlines why we don't believe that the wife established, the former wife, that it was in the best interest of the minor child to have her name changed. And we have relied in our brief heavily on the Wilson versus Smith case out of this court. Judge Wallace was on that panel in a concurring opinion. And it's important to, if you read the chronology of these cases on name changes, that one of the first factors is that there must be a finding that it's in the best interest of the child or that it's necessary for the welfare of the child. But when you read the Wilson-Smith case, they go on to say that the court should order the change of a minor's surname over the objection of one parent only where the evidence affirmatively shows that such a change is necessitated by the welfare of the child. And if you read all of the various cases, and there aren't a lot of them here on name changes of minor child, that becomes a second step basically in cases where it's a parent who has objected to the name change, that you must find that it's necessary for the welfare.
What kind of things would you have to prove to show that the name change is in the best interests of or is necessitated by the welfare of the child? And what kind of things would prove that?
There are cases of long-term incarceration for crimes of notary that are public, where the minor child's name associated with the parent who's committed the crime is well publicized and could reflect the enjoyment of life of that child, or where there's a huge security risk for a particular child. There are cases where there is a complete abandonment of the child, meaning that there is not only no contact but no financial support. I didn't see a case, I stand to be corrected, but I didn't see one where they didn't have both those components even when they did factor it in, that it was an abandonment of time and money, which was not this case.
Is there any case where it's sufficient that the parents that seeking the name change is interested in having the last name of the child conform to the parent's name?
There are, outside the state of Florida, there are some cases, but in the state of Florida, in a divorce case with a minor child of two parents, I have not seen that case where that name change on the standard that you've just raised. In fact, in the Wilson versus Smith case, the mother argued that she wanted to change the name so the mother and child would have the same name. What's interesting about this case and different than the other cases is that Ms. Conklin caused this problem. She and her daughter did have the same name. For her daughter's entire life, they both shared the name Arisman. So she has created this issue that she would like her daughter's name to be the same as hers. If she hadn't changed her own name, which she was using for over 2 years after the date of divorce, she used it during the marriage, she used it not only personally but professionally, as we put in our brief and we established in the record, she decided to create that difference between herself and her child. And as a result, now she wants to change the child's name. Why was it necessary for her to change her name It creates that difference between mother and daughter. We believe that it's pretty clear that the child did know her name, the child had used that name, the child did have a relationship with the paternal side of the family, that the father had not abandoned the child. There were several hoops that he had to jump through in order to have his share of parental responsibility rights reestablished, but he was on his way. The grandparents were involved, the paternal aunt was involved. I think that it showed quite the desperation to change the child's name in the transcript, where the mother made absolute statements that the only family name that the child is associated with is Conklin. That was not truthful. When you go through the record and you see the different circumstance, the child knew her grandparents, knew her father. She had contact with the paternal aunt. The mother obviously would like her name changed, but didn't establish why it's helpful for this child. There was no evidence demonstrated that the child was at risk. There was no evidence that the child had suffered some kind of upset or questioning of why her name is different than her mother's, because it hadn't been different. There could be no evidence or testimony because the child was registered at a preschool, registered at her activities as Arisman. There had not been that issue, so there was no evidence to support it. It was speculating that this child would later have problems.
Well, Ms. Conklin tells us in the brief that the father has a limited, if any, role in the child's life. This is post-dissolution.
She argued that, Your Honor, and it's very clear from the record that there were some hoops that the father had to go through. He was severely depressed. He was drinking. He was in inpatient treatment at the time of the divorce, all facts known to the mother when she didn't change her name. And she went into after a rehab facility, went into a halfway home, then he re-enrolled in school and attempted contact the way that it was outlined in the marital settlement agreement. It had to be through his parents. His parents would supervise. The father and both the grandparents, the paternal grandparents, testified of their efforts. The father testified that when he was in Boca at the halfway house and in school, he would sometimes ask 4 or 5 times a week that he would travel across the alley to Naples to see the child, only to be told that the circumstances had changed. If the emails are reviewed, there were excuses raised. And the mother herself, when she testified, she said she's a very busy person. She's on all kinds of committees. She's busy at work. She and her daughter have a lot to do. All of the standard things we see in cases where someone is throwing up roadblocks to contact. The husband testified clearly of his attempts to work with his attorney to get some time, that there were communications with Ms. Conklin's attorney to try to get parenting time. Ms. Conklin was asked under cross-examination at the hearing, well, why wouldn't you even agree to let the father see the daughter while he's here in town for this trial, or the paternal grandparents? And she basically hemmed and hawed about what that was and late notice and who requested it. But the fact of the matter was, the father and the paternal grandparents were there. They had asked in advance of the trial, which was well known to the parties. The trial was in September, for contact, and she didn't make it happen. So the husband testified that when he understood through new representation that there is something called a motion to enforce and motion for contempt, that was filed. That instead of sitting back trying to work it out, trying to go through his parents, trying to go through his attorney, was not working, and he filed a motion to enforce. The mother even tries to argue that the father was delinquent in his support obligations and had not financially supported the child by saying that his parents wrote the check. Well, if you go back and you look at the marital settlement agreement that the mother entered into, the agreement always was that the parents were going to write that check on behalf of the father. So it's not even, a sincere argument to say that he wasn't financially supporting the child. That was his child support obligation, through his parents to pay that check. I think that, this court has seen a lot of high conflict divorce cases come through on appeal, and I think it's interesting to note that in her own answer brief, the mother cannot even bring herself to call Mr. Arisman father. She identifies herself as mother, and he's the appellant. And that's consistent with the tone and her testimony throughout the hearing. She tried to rehash events that, from her perspective, were horrible events during the divorce, yet this is the man that she agreed would have contact with her daughter, who she didn't feel the need to change the name at the time, not even her own name. She tried to rehash things that existed before the final judgment. She did not bring up any evidence or testimony that there was anything that would put the child at risk. There had been nothing in the 2 years since the final judgment had been entered. Both parties wrote not very friendly emails once in a while, but there was no domestic violence, no threats, and nothing with regard to the child that would make the court be concerned about the safety or welfare of the child. There's absolutely no doubt that if Ms. Conklin would like to distance herself from her former husband, that she should be allowed to change her name. But the statute on name change requires the consent of the other parent for very good reason. That parent should be consulted. These parties got married, they decided to have a child, they jointly named this child, and there is absolutely no basis in the record to change the name. I don't think that Mr. Erisman was quite as articulate in the record below with regard to his position, but I think he was very clear when he said, I love my daughter, I want to be in her life, I haven't abandoned her, I've hired counsel to pursue my parental rights, I'm paying support, I want her to have contact with my family and know my family. And those are all the reasons why we have hearings to see whether or not, it should be changed, whether or not there's consent. But there was not one shred of evidence that I believe that anyone could argue that there was testimony or evidence that the welfare of the child was at risk, or there was a necessity for that particular reason. I've gone through and addressed, some of the facts, but I know this court's reviewed it, and I think if the court doesn't have any other questions, I'll reserve my time.
May it please the court, my name is Erica Conklin, and I am representing myself in this appeal. Therefore, for purposes of the oral argument, I will be referring to myself in the third person as the mother. Your Honors, this court should affirm the judgment of the trial court because there was competent, substantial evidence below that the name change was in the best interest or the welfare of the minor child. The determination of a petition for name change for a minor child is a very fact-specific inquiry, and the trial court is vested with broad discretionary powers in determining the issue of the child's welfare and best interests. The appellate court sitting here today cannot reweigh the evidence on disputed factual issues. For the competent substantial evidence standard, as a general rule, in a decision in a non-jury case based on a finding of fact from disputed evidence, it's subject to a competent substantial evidence standard of review on appeal because the trial
Ms.
judge...
Conklin, help us out here. What is the competent substantial evidence that would support a trial court finding that changing this child's name is in the child's best interest or is necessitated for her welfare?
Your Honor, at the trial court, the mother presented evidence that it was in the child's best interest to have her name changed, to bear the same name as the mother. The mother testified that since the date of the child's birth, she had been the one who had provided all the nurturing, physical, and emotional support for the child. The mother testified that she chooses, registers, and pays for the child's preschool, health insurance, physicians, dentists, camps, caregivers, extracurricular activities, travel, housing, clothing, food, and all necessities of life. The mother has parental responsibility for the child 24 hours a day, 7 days a week. The mother is raising the child alone. The mother testified that the minor child now, and as she grows, is going to need to know her place within the family and within society. The mother testified that the only family the mother-child has ever truly had consists of herself.
Well, aren't there, there's got to be millions of children all over this world whose name is different from their mother's name. So, and I don't think there's any empirical evidence, certainly none presented at the hearing, that those children are damaged as a result of that. So what is there specific to this case that would support a finding by the trial court that changing this particular child's name was in her best interest or necessitated for her welfare?
Your Honor, in this particular case, it's a situation where, as Ms. Hall described, the divorce took place when the child, the mother separated from the father when the child was 17 months old. As you can see from the facts, there was severe domestic violence in the child's presence. The court, when you look forward to the best interest of the child standard, the case of Levine versus Best states that the trial court is to look at the same statutes that determine child custody cases. Those sections are set out in section 6113 subsection 3 of the Florida statutes. And that statute says the determination of the child's best interests shall be made by evaluating all of the factors affecting the welfare and interests of the particular minor child and the circumstances of that family. In this family, it's undisputed that the mother, pursuant to the marital settlement agreement, shall make all decisions with regard to the health, education, and welfare of the minor child. The mother had full physical custody. The father's visitation was limited to supervised visitation, which he was not exercising. The evidence before the trial court was that in over 2 years, the father only made 5 requests to see the minor child. Now, Ms. Hall has said that the father stated in his testimony that he would try to see the child 4 to 5 times over the course of the week. But the evidence before the trial court and the record states otherwise. The husband agreed that the only communication between himself and the mother came in the form of text messages. And all of those text messages were presented in the mother's exhibit, which is at the record between record 83 and 165. That exhibit, which contains all the communication between the mother and the father, in 2 years, there were 5 dates that the father asked to see the child. The record citations are February 5th, 2013, that's at record 87, February 17th, 2013, that's at record 90, February 22nd, 2013, that's at record 93, September...
Well, is there a case or some other authority you can point us to that says that a history of not visiting as much as one might or conflict between the parents are sufficient reasons to support a name change when the other parent opposes it?
Your Honor, the case law in the state of Florida, most of there's few cases that are on point here, and most of the cases, when the appellate court finds that it was not in the best interest to change the child's name, it's because there was no evidence below that the change of the name would be in the child's best interest. For example, in some of those cases, the father says, well, I think the change should be because I want the child to carry my name, or I want the child to continue the family history, or because it's, quote, old-fashioned, and that's exactly what the husband in this case stated. He said that his objection was that it was old-fashioned, and that's the way things work. And there are the Girton case, in Girton versus Andrew and McKay versus Heike, both of those cases hold where the father says that the only reason that he wants to take the child's name was because he fears he wants the child to maintain that familiar name is not sufficient to change the child's name. In this case, the judge heard multiple evidence from the mother and from the father. And of course, it was disputed. But that judge, he was sitting there and he had the discretion to determine the issue of the child's best welfare and best interest. He had the ability to weigh the testimony of the mother and the father. He had the ability to make determinations as far as the credibility of the witnesses, and those decisions of the trial court are not to be questioned by this court. The question before this court is whether there was competent substantial evidence to affirm the name change below, and I represent to you that there was. Florida case law holds that the consideration of the child's best interest and welfare are one and the same. The Stam versus Stam case says that in custody proceedings, the prime consideration is the welfare of the child. All factors affecting the best interest and welfare of the child must be considered. Ms. Hall raised the Wilson case, which was decided by this court. The Wilson case is clearly distinguishable from this case. Again, in the Wilson case, there was no evidence presented as to whether the change in the name was for the child's best interest. And also in that case, the magistrate had placed the burden of proof on the father as to why he was objecting to the child's name change, rather than requiring the mother to establish why she believed the name change was in that child's best interest. Importantly also in Wilson, it wasn't just the last name of the child that the mother was trying to change. The mother was trying to change the minor child's first, middle, and last names. And the mother, when she was asked why she was changing the child's name, testified only that she never liked the name. She didn't give evidence to the court that the mother here did below. She didn't give evidence that she was the only one raising the child, that she plans, enrolls, pays for, and transports the child to school, to extracurricular activities, to doctors, to dentists, to her caregivers. The mother is the one that interacts with the minor child's peers and the peers' parents. And when the mother picks up the child from school, picks her up from ballet, from tap, from piano, from all of those things, there's a security issue with the having the same last name as the mother when they are picked up at school, when they register for dentist and doctor's appointments, when they travel. The mother testified that she didn't want the minor child to be subject to feelings of embarrassment or abandonment because she's bearing a last name that has nothing to do with anyone, that has a presence in her life. In this case, there was testimony that since the date of the separation, in November of 2011 through the date of the trial in September of 2014, which was almost 3 years, the father had only been in the minor child's presence for 7.5 hours. The mother noted that if the father in the future wanted to have her establish a relationship with the minor child, it would be on him to do so, and it should have nothing to do with what her last name was. And in fact, the father testified and admitted at transcript 9091 that if the minor child's name was changed, it would not affect his relationship with her. Your Honors, I can go through each of the statutory factors and the evidence that the mother presented on those, but those I think are very well laid out in the mother's brief. In conclusion, the mother carried her burden of proof below. There's ample basis in the record to support the finding made by the trial court that it was in the minor child's best interest to bear the same surname as her mother. For these reasons and those set forth in the mother's brief and in the record, there was competent substantial evidence to support the trial court's finding that the mother is the sole caregiver and custodial parent, and that it's in the minor child's best interest to bear her surname. I would also point out that specific findings of fact were not required in a name change case, especially here when the basis for the award is reasonably clear and supported by the record. But even if they were, the trial court specifically found that the name change was in the child's best interest, and he specifically found the mother was the custodial parent and the sole caregiver. Therefore, I respectfully request that this court affirm the trial court's judgment in granting the change of name, and thank you for your time today, and unless there are any other questions, I will be seated.
Very briefly, Your Honors, the standard that the court relied upon to change the name must be accurate, and there wasn't any findings with regard to the best interests of the child, or that the name change was necessary for the welfare of the child. There was an objection. So you have to use the right standard. And I respectfully disagree with Ms. Conklin that the Wilson versus Smith case, in the facts, they said the mother argued that the child's father had limited contact with the child. He had more time to serve in prison, that he was not financially supporting the child, that he did not support the child's mother. So there were many other reasons alleged by the mother other than just wanting the same name change. I don't think I have to remind you, but the financial responsibility for the payment of school and activities, that was determined pursuant to the Florida Child Support Guidelines in their agreement. It has nothing to do with whether or not a name should be changed as to who is paying what portion of those activities. There was a lot of he said, she said with regard to what happened during the marriage. We tried to limit that. The judge did hear some of that, but it was rebutted testimony with regard to what happened during the marriage. Judge Wallace, you specifically asked Ms. Conklin whether or not she had found a case where there was a limiting or where a parent did not exercise all or some part or of their parenting time, and the question respectfully was not answered. She obviously has not found a case where a name change was granted on that basis alone. There were no real findings by Judge Foster in this ruling as to why he thought it was in the best interest of this child, nothing about the welfare. Again, this need to have daughter's name match mom's was orchestrated by mom when she requested her name change. If she didn't want the child to have a different name, if she didn't want any, what she's now saying here before the court, some security risk of picking the child up from ballet or school, why'd she change her name? That's not enough. I think the record's clear that mom wanted to change both names. The father testified about all his efforts and his parents' efforts, who were the designated go-between for parenting time. They testified of the number of attempts they made. This is just another factor that the court can consider where mom is attempting to distance the child from her father. We'd respectfully request that the final judgment changing the name of this minor child be reversed. Thank you.